Hello, everybody in the audience watching today's webinar. My name is Babak Shamsi. I'm one of the attorneys from Beresford booth. And today I'm going to be talking to you about the joys and perils of community living. And what I mean by that really is that this is going to be a presentation about condominium and homeowners association. My bread and butter from where I started as an attorney all those years ago, it feels like now. And this is not meant to be any kind of an exhaustive coverage of the issues that condominium and homeowners associations face or their owners face. This is going to be really broad level, high level stuff because, frankly, they deal with all kinds of issues, everything from corporate governance and, issues with lending all the way down to, someone's dog is barking too much. So, it really covers the gamut. So this is not really the forum for going through all that stuff, but nonetheless, I'm going to talk about some of the applicable statutes and some of the applicable governing documents that sort of help people to run the communities that they live in and hopefully go through some of the joys and perils of living there. Otherwise, I think the title was perhaps a little bit misleading, but hopefully catchy enough to get some attention to watch this as I go through. So essentially, there are multiple statutes that govern condominium and homeowners associations, and it is really important to know which statute your association falls under. And there are a number of exceptions and other caveats that kind of go into this. But as a general rule, there are 4 potential applicable statutes. And again, there are some exceptions, but this is covering most of the communities that people live in the state of Washington. And so there's RCW 6432, the Horizontal Property Regimes Act, colloquially known as the quote-unquote Old Act, Condominium Act, and it governs condominiums that were formed before July 1st, 1990. Then there's RCW 6434, the Condominium Act, which governs condominiums formed on or after July 1st of 1990, but prior to July 1st of 2018. That's often called the quote-unquote New Act, although it is no longer the newest act. There's RCW 6438, which governs homeowners associations. And, there's a kind of a confusion in that people will often refer to condo associations as homeowners associations in their titling, which doesn't really help anybody as far as keeping things straight. But this statute covers homeowners associations that are not condominiums. So, a number of houses that are in a community, but they still have, rules and regulations and declarations and that kind of thing that govern what they do, and they've been formed under this statute. And then there's finally RCW 6490, Washington Uniform Common Interest Ownership Act, a bit of a mouthful, but it governs condominiums. Actually, it governs condominiums and also homeowners associations that are formed on or after July 1st of 2018. So I'm going to go through each of them one by one, and there's a comment that is perhaps I don't know if it should be shared amongst the public, but it was an inside joke back from my days of representing condominium and homeowners associations, before I came to Beresford booth, and it was that friends don't let friends buy condos. Now, it's a joke, of course, because there are a lot of benefits to living in condominium associations. There are benefits to living in homeowners associations because, for example, you share the risks and responsibilities involved with community living. People pay assessments and they pay special assessments to cover things like, if the roof leaks or that kind of thing. Whereas if you're living at home by yourself in a house that you own all, totally your own, and you have to re-roof your house, you're covering the entire cost of that, and that could be quite a hit. By the same token, anybody who's lived in a condominium or homeowners association knows that there are a lot of rules and there are a lot of restrictions and things that you have to abide by. And to a certain degree, you're ceding a certain amount of authority to other people who are, running the show, often the board of directors, and, there's also management companies. And so there's a bit of a give and a get when it comes to community living, and it's not for everybody. And that joke aside, there are actually a lot of benefits to living in those kinds of communities, especially when they're really run well. And I have seen condominium and homeowners associations that are run well, despite all the horror stories that are out there. There are good ones, and there are boards that are really responsible. And, I often commend them for for taking their job seriously, because usually those people, the board members, they're made up of the owners, made up of the very people that they're governing. So anyways, I digress. Going back to the statutes, the first one is RCW 6432, the Horizontal Property Regimes Act. Again, the so-called Old Act that governs condominiums created on or before July 1st of 1990. This statute is a relatively sparse statute when compared to some of the statutes that were passed later, like RCW 6434 and 6490, which I will get to, and which both govern condominiums created later on in time. But it doesn't address a lot of the issues that those statutes address. I mean, everything from reserve studies to condemnation to even listing out the powers of the association and board. It just leaves much to be filled in by the governing documents of the homeowners association or condominium association. So to a certain degree, that statute is often not very helpful when it comes to trying to figure things out where the governing documents of the association are silent. So, it's a statute that obviously the legislature realized to a certain extent was deficient, and so subsequently ultimately passed these other ones. But, there are some interesting specifics, like, for example, it permits the shutoff of utilities in the event of unpaid assessments, which is not common otherwise, and is a pretty dramatic form of coaxing owners to pay their dues. Another biggie is that it lacks the super priority lien protection over lenders, and oftentimes the condominium associations that were formed back in that area have declaration provisions that essentially make it impossible to get a super priority lien protection. And what that means, by the way, is that the association, when it's owed dues, it has a super priority lien in that even though there may be a first mortgage that's entitled to, payment first, the association gets a lien over usually 6 months of dues, where they can collect that first and essentially, they have a priority to that amount of money. And the old Act condos often have provisions that did not allow for that. And the statute was of no protection there either. So RCW 6434 and 6490 subsequently filled in the gaps even for condominiums created on or before July 1st, 1990. Now, not in their entirety, but certain gaps, were filled in and that kind of thing. And again, I mentioned them that, those statutes, reserve studies and termination of condominiums, condemnation, et cetera, were kind of made applicable backwards to those older condominium associations, except that it was for events that came in the future. It wasn't retroactive to things that had happened prior to the passing of those statutes. Brings me to my next act, the Condominium Act, RCW 6434, the so-called quote-unquote new act, which is now probably an outdated term since there is another act that followed it. It governs condominiums created after July 1st, 1990, but before July 1st, 2018. It's far more detailed than RCW 6432. It addresses, things like reserve studies, condemnation, termination, powers of the association, the lien super priority that I mentioned just previously, and much more. It is a far more detailed statute. It is generally a lot more helpful in terms of interpreting what a condominium association can and cannot do, and its interaction with the condominium declaration and what those provisions provide. And so it is a much more robust statute. It also permitted pre-existing communities to opt in. So condos that were governed by 6432 could opt in to the Condominium Act, but didn't have to opt in into the entire statute. So they could essentially pick and choose. The only risk, of course, of picking and choosing is that if one picks a certain portion of the statute to opt into, it has to opt into the correlative obligations, liabilities, and restrictions. And the reason for that, of course, is if it gets one of the benefits of the new statute, if there are rights and responsibilities or restrictions that go hand in hand with that, it can't really, pick and choose parts of the act and then not take correlative parts of the act that are essentially tied into those. But it wasn't an all or nothing proposition. There was some picking and choosing allowed. And so there are plenty of old act condominiums that, amended their declarations to take advantage of some of the provisions afforded by the Condominium Act, and that was something that happened quite a bit back when I was practicing representing homeowners associations and condominium associations at that time, and still something that goes on now. So that takes us to 6438, the Homeowners Associations Act. This is not for condos and created prior to July 1, 2018. This act is possibly less detailed than even the old act condominium statute. It really is fairly sparse. It leaves a lot to be filled in by the governing documents. In truth, it is often silent on many provisions that would be helpful to have some clarity on. But interestingly enough, despite its lack of detail, it has really specific provisions about some very interesting things, like flags in electric vehicle charging stations, solar panels, political science, adult family homes, things that would not necessarily be at the forefront of what one might consider to be, the most important parts of living in a homeowners association or governing a homeowners association, but very specific and right in the statute. So that was an interesting decision by the legislature in terms of this particular statute, that they essentially determined that it was worth putting in right into the statute information about solar panels and charging stations and things like that. And so the RCW 6438 is sort of a mixed bag. It's fairly sparse, but it has some very specific provisions. So if you're living in a homeowners association, and again, not in a condo that was formed prior to July 1st, 2018, it is very likely that your association was organized under this statute. And so knowing those specific provisions that may apply could be very important, because it's important to know kind of what gaps are filled in if it's not in the declaration, or if the declaration, hopefully not, conflicts with the statute, knowing whether that conflict is permissible or not. And that brings us to WCIWA, which is kind of a goofy acronym, to be totally honest with you, but RCW 6490, the Washington Uniform Common Interest Ownership Act. I'm going to refer to this as the act going forward here as I talk about it, so I don't have to keep repeating WCIWA. But it's a comprehensive statute governing both condominium and homeowners associations. So now pretty much everybody, there are some exceptions, but for the most part, everybody we're talking about under the prior statutes that I discussed gets swept up under this statute if they were formed after July 1st, 2018. Pre-existing communities that were formed under those statutes can actually opt into this statute. But if they do so, unlike with the Condominium Act, where communities that were formed under 6432 could kind of pick and choose which parts of 6434 they wanted to opt into, here it just replaces the whole thing. You're in or you're out. And the thing about the Washington Uniform Common Interest Ownership Act, which I just repeated in its entirety instead of saying the act, essentially is a very detailed statute. I think the point of this, to a certain extent, was that the legislature wanted to fill in as many of the gaps as they could, try to create a comprehensive statute that didn't have sort of lacking provisions, areas of gray, just tried to really pick up as much as they could. And so this statute was sort of an effort to pick up the loose ends. So a condominium declaration will still supersede inconsistent provisions of this act unless the association opts out of some or all of the declaration. So the declaration doesn't necessarily have to comport entirely in certain aspects, but essentially, if the association affords rights, once again, it has to kind of go with the responsibilities, liabilities, restrictions that go along with it. Another interesting provision is that there are some specific provisions of this new statute that just apply to everybody, period, that formed under those other statutes. I say period, but there are some small exceptions that I'm not going into today, because these are exceptions that do not cover most of the communities that I'm talking about would probably be individuals interested in watching this webinar. But RCW 6490-525 about budgets and sub 545 on reserve studies, those are applicable to everybody and will actually override inconsistent provisions of the prior statutes. And also, this statute doesn't override inconsistent provisions of the governing documents, as I mentioned, except for homeowners associations formed under 6438. So that really kind of brings those into compliance. So that's my coverage of the statute. Again, it's really top level, and it's very much kind of a sort of high-level view of what these different statutes are. And it's very important to know which statute governs your association so that you are armed with the knowledge of what you can and cannot do by law when you're looking outside of the governing documents, which brings me to my next section, which are the governing documents. What are the governing documents? Well, there's a number of them, but I'm going to talk about the most important ones for community living. You have the Declaration, which I'm calling the Constitution of Community Governance, bylaws, the process of community governance, and the rules and regulations, which I call the life of community governance. So what are these? The Declaration, often also called the CC&Rs, are basically the Constitution in the sense that they set the overall rules of what a condominium association can and cannot do, what the rights are, what the responsibilities are, and what the basic definitions of all of these various aspects of community living will be. You know, a declaration will cover everything from what happens when there's damage and destruction to the condominium. You know, how does a condominium get terminated or homeowners association get terminated? What happens in the event of condemnation? How are the units defined, or, for example, or the lots defined? Are there common areas? How are the common areas defined? Are there limited common areas, which means that they're, you know, essentially designated for use by particular units, but are not technically part of the unit or the lot? Often parking spaces or storage spaces that are not, you know, directly within the boundaries of the owner's property. How are those dealt with and defined? You know, what are the powers of the association and all of that? So that often comes in the form of the CC&Rs or declaration, and I call it the Constitution because really it governs everything at its core. And if there's a provision in the declaration, generally speaking, to change or to do something inconsistent with that provision of the declaration properly, an amendment would be required, much like, you know, if we were going to amend the Constitution of the United States. You know, it's sort of that high level, top level governance that flows down. This is sort of the same thing. It's the core. And so if you want to change, for example, how insurance is handled or how damage and destruction are handled, if there are express provisions in the declaration that say one thing, that's governing. And, you know, so long as it's legal, and it's governing, and to change that, it's going to require an amendment by the owners, and the process for amending, like the voting percentages and all of that, are very likely outlined in the declaration too. So knowing what's in the declaration is perhaps the most important thing in terms of living in a homeowners association or condominium association, because really everything, I don't want to say everything you need to know, but you should know that document inside and out so that you know what your rights and responsibilities are. Because unfortunately, there are associations and boards and property managers and owners out there who don't know and don't act in accordance with the declaration all the time. And that can create problems. You know, these documents are there for a reason. They should be enforced for a reason, especially if they're done well, which is a whole other topic of discussion of whether the declaration for an association has been properly put together. I've seen them run the gamut in quality, which is probably not a surprise to anyone. But, you know, the declaration really is sort of the core of community living and should be understood very well when it comes to rights and responsibilities. Then there's the bylaws, which is, I call the process of community governance. This really is kind of like, you know, how are board members voted in? Who are the board members? You know, president, what's the president's responsibilities? Vice president, secretary, treasurer. You know, can they form committees? What happens if a board member resigns? What happens if a board member dies? What's the process for replacing them? It's really about how the community is governed in its nuts and bolts, as opposed to what the rights and responsibilities are. Now, there are sometimes overlap, which I generally dislike, but I've seen times where the declaration bylaws bleed into each other. I do consider them personally to be different documents that do different things. The declaration is recorded with the county because anybody who's buying into a property governed by one of these associations needs to know in advance, be on notice of what the declaration says and what the rights and responsibilities are. Bylaws are often not recorded. So the bylaws cover, the process of community governance and all of that. And there's some other details in that too, but that's kind of the general role that plays. And then, of course, there are the rules and regulations, which I call the life of community governance. And what I mean by that really is that the rules and regulations, especially for those associations that actually have them, pass them, adopt them, and promulgate them to the owners, really govern what people do on a daily basis in terms of community living. They'll cover things like issues with pets. They'll cover things about quiet hours. They will cover things about, perhaps painting and just other things that are day-to-day issues potentially that aren't going to necessarily be in the declaration, and which they may be kind of day-to-day living to the point where if the association wants to change it, they don't want to go through the process of having to amend the declaration. They may just want to pass new rules. So it's important to know what the rules and regulations are, and the rules and regulations have to be in harmony with the declaration. If the declaration is silent, a rule could potentially be adopted to address issues, and again, it will depend on the rule and what the issue is, and this isn't really the forum to discuss whether the rules are valid, but rules and regulations generally have to be in harmony with the declaration because it cannot supersede an inconsistent provision of the declaration. I have seen this from time to time where the board of an association decides to adopt a rule in the rules and regulations that's expressly not permitted in the declaration, and that's a problem because that's not enforceable. The declaration trumps the rules and regulations, and there's a reason for that. Again, right, when someone buys into a property, the declaration is a public record. They know what they're getting into. It's been adopted properly by the association, in accordance, or the declarant, in accordance with whatever process they were supposed to follow. And to amend those provisions, it requires an amendment that follows the process, whether that be 2/3 of the owners having to vote on it, or 3/4 of the owners, or even unanimous voting. If the association or board could just adopt a rule that flies in the face of the declaration, and again, not go through the process of amendment and do it in a document while people are just living there, despite having bought the property, having looked at the recorded declaration, it would basically create all kinds of chaos. So it has to be consistent with the declaration. And the rules and regulations are also often where you will find things like the fine process and fee schedule for fines, and the notice and opportunity to be heard in the event that the board is going to levy a fine on someone for violating the rules. That's often where that information comes into. So that's a critical place to look to see what kind of fine or fee schedule there is for violation of rules, and understanding what the process is to deal with, a potential fine being levied by the association. So the governing documents are very important. Again, declaration, bylaws, rules, and regulations are biggies. And I would say, despite the fact that I spent several slides looking at the statute, the first place any owner or board member should, or even property manager should be looking at to understanding their condominium or homeowners association is at these documents. Make sure to understand the governing documents of the association because, again, they're called governing documents for a reason. They really govern the way people live there. And it's really important to know what you're getting yourself into, what rights you have, what responsibilities you have, and what mechanisms for enforcement of these documents there are. Because, I often see nightmare scenarios where there's a board and they just don't enforce anything. And, perhaps some people may think that sounds great. I don't have to deal with someone telling me what to do. But that also comes with the cost of then living in a community where there are no rules. And, especially in condominiums where people live in apartments or even in communities where there's attached walls and townhomes, that kind of thing, these rules can become very important because what your neighbor does could, directly influence what you do or impact what you do in a way that perhaps that wouldn't happen if you're just living in a single family home that's really not connected to anybody else. So understanding the governing documents, enforcing the governing documents, and making sure that they're well-prepared governing documents is very important. And, having a lawyer look at the declaration and the rules and regulations from time to time is not a bad idea. Just to make sure that, you've taken advantage of all the things that you can take advantage of to help your association, or at least know that if there are things out there that you could do, you have enough information to know whether it's right. So at this point, that more or less concludes my presentation for today. I hope you found it helpful. If you have any questions, my contact information, email, and phone number are on the last slide here. We work in a number of different areas, real estate and business to all kinds of other matters, estate planning and family law and on. And if you have questions about the topics herein, if you're a homeowner or a board member or a property manager, or just generally want to chat about this kind of thing, please feel free to contact me. I hope you've enjoyed the presentation and found it at least a little bit helpful, even at a high level. And I hope you have a very